The red flag law, also known as the Jake Laird law, has been around since 2005 in Indiana. But as prosecutor Ryan Mears told us today, the law can only do so much. Our Alyssa Donovan explains why the law was developed and why it still needs to be perfected.
Ever since he was a little kid, he wanted to be a police officer.
Mike Laird remembers how happy his son was when he joined the Indianapolis Police Department.
But he took the job as a police officer very serious. I always tell everybody it was like this for the job in him. It was meant to be.
In 2004, just 4.5 years into his time on the force, Officer Timothy Jake Laird was shot and killed by a man who had previously had his weapons taken away by police. Months before the shooting, the man had been hospitalized for an emergency detention, and police had seized his weapons. After his release, he wanted them back, and police had no legal authority to keep the weapons away from him. The Jake Laird law, passed in 2005 and amended in 2019, aimed to address this issue, and it has made a difference.
I have police officers call me and departments call us all the time, still to this day, saying, hey, I got to use the Jake Laird law today.
The law allows the seizure and retention of firearms from dangerous and mentally ill individuals who may present risk of injury to themselves or others. But as Marion County Prosecutor Ryan Mears explained today, it does have loopholes, one of which has been made very clear in light of the mass shooting at FedEx late Thursday night.
This case does illustrate some of the shortcomings that exist with this red flag law. There's a significant limitation to the law in terms of if we initiate these proceedings, there's nothing prohibiting that individual to go out and then purchase an additional firearm or 20 firearms. They are free to do that until there is an actual documented finding where a judge says, I can find by clear and convincing evidence that this person has a propensity for violence or mental instability.
Under the statute, the prosecutor's office has 14 days to collect that evidence, which Mears says is not enough time to subpoena medical records and conduct interviews. The law also only authorizes a search warrant to seize a weapon, but not the ability to get a court order to acquire medical history,
which would be particularly relevant in trying to make these types of determinations.
The statute has been used hundreds of times in Indianapolis to allow officers to seize weapons. But even Laird says he's aware that the law, named in honor of his late son, is a tool that needs tightening.
It's just a step to try to get things under control. By no means is it the solution.
I'm Alyssa Donovan, WRTV.